Hi there, I'm Chris Murray. I'm a Senior Associate here in the Procurement team at Bird & Bird.
And I'm Claire Gamage, an Associate in the Procurement team at Bird & Bird also.
And today we're going to talk to you about the important Court of Appeal decision in Faraday versus West Berkshire. Now, the facts and the judgment in this case are relatively complex, and we're not going to go through it in detail in this short video, but what we're hoping to do is give you a summary of the case, as well as the 3 top takeaway points that we think are of interest to contracting authorities and bidders alike who are involved in public procurement processes.
So this is an appeal case from the High Court which sought to answer a few key questions which have arisen over the years in respect of determining when a development agreement should be advertised and procured in accordance with the public procurement rules. In this particular case, the development agreement itself was subject to a competition. The council had advertised the competition, but not in accordance with the public procurement rules. So the opportunity wasn't advertised in the OJU, and the procedure followed wasn't exactly in accordance with what would be otherwise required under the public procurement regime. Now, Faraday, the claimant in this case, was unsuccessful in that competition, and St Modwin's were the winning bidder. So the council and St Modwin's entered into a development agreement in September 2015. There were some immediate obligations on St Modwin's to carry out certain services right from the outset of entering into the agreement. However, what's important is that there were no obligations on St Modwin's to commence works unless and until it chose to draw down parcels of land by exercising an option in the development agreement. Now, what the High Court said was this wasn't sufficient to create a public works contract which had to be advertised in accordance with the procurement rules. However, the Court of Appeal said although there was no immediate binding obligation for St Modwin's to carry out works, the council had put itself in a position where it would be in breach of the procurement rules in the future. This is because at the point St Modwin's exercised that option, the council had no choice but to grant a long lease to St Modwin's, which kicked in a number of development obligations in St Modwin's, and this is what we call an anticipatory breach. And I guess that's the first key point to take away from the case, is that even an anticipated breach can constitute a breach of the public procurement rules. Ultimately, the Court of Appeal decided that overall the agreement was awarded in breach of the public procurement rules, and therefore this invoked the remedy of a declaration of ineffectiveness.
Now, the second key takeaway point relates to the council's use of what's known as a voluntary transparency notice, or a VET notice. A VET is a notice that is published in the OJU, which notifies the market that a contracting authority intends to award a contract without first having advertised that contract in the OJU. A VET notice has to contain 2 important points. First, the object of the agreement to be entered into, and second, the legal justification for awarding that agreement without advertising it in the OJU. Now, although the VET notice in this case did refer to the fact that it related to the development of the London Road Industrial Estate, it stated that the main object of the contract was an exempt land transaction. Now, the Court of Appeal said that that was not just oversimplification, that was in fact wrong, or at best it was misleading, because the agreement was for so much more than just the disposal or the transfer of land. It contained all of those very complex provisions that Claire's already mentioned on development and service provisions. Next, on justification, the VET notice said first of all that the award of the contract was justified because this was an exempt land transaction, the Court of Appeal having already decided that this was misleading, it couldn't be relied on in terms of justification. But then also in terms of justification, the VET notice said that the agreement contained no binding obligation on St Modwin's. Now that, the court said, even if it could be interpreted as to mean no immediately enforceable binding obligation, was still very unclear. Now, generally, I think what I like as well from the judgment is that the court says that the VEET notice described more what the contract was not rather than what it actually was. So ultimately the Court of Appeal decided that the VEET notice was invalid and it couldn't be relied upon by the contracting authority. I think what this means practically is that it reinforces the fact that VEET notices are not a silver bullet, as some contracting authorities think that they are. And in fact, many of the VEET notices that we see that have been published, we think probably wouldn't satisfy the requirements as set down in this case. And the other point then is to say that the threshold in terms of narrating the object and justification for the award of that contract is now quite high following this case. The final takeaway point then relates to the Declaration of Ineffectiveness itself, as Claire's already mentioned. This was the first such declaration granted by an English court, and given that this remedy was first introduced in 2009, there has been a general perception that in order to get a declaration of ineffectiveness, it would be quite challenging and only really in exceptional circumstances. This case demonstrates that in the right circumstances, a declaration of ineffectiveness will be granted. It is worth bearing in mind, though, that the declaration was not granted by the court. It was, in fact, agreed between the parties and then essentially ratified by the court. So there's not a huge amount of guidance from the judgment on what the consequences of that declaration, or, importantly, the civil financial penalty that goes with it.
Thank you for listening to us. We hope that provides a helpful summary of what is a very complex case, and do keep a lookout for future procurement law videos which we intend to publish in the future.